Chapter 22. Parties to Actions. Sec. 117. A brief comparison of rules at common law and under the Code. The law governing parties to actions forms an important part of the subject of procedure. There were no rules connected with the science and practice of pleading so important as those which relate to the persons who should be made parties to the action. A careful study of the situation, rights and the relationship of parties, who may be held, and who may not be held liable, must be made before the pleading is drafted. And before we can fully appreciate and understand this branch of the law, a consideration of the nature of the change from the common law to the Code is essential. When the scheme of merging all existing civil actions prevailing in common law and equity into the one civil action of the Code was designed, it was necessary to radically readjust the law of parties. It has often been stated that the rules of parties prevailing in equity were chiefly adopted in the Code. The New York Code Commission said, "The rules respecting parties and courts of law differ from those in the courts of equity. The blending of the jurisdiction makes it necessary to revise these rules. If we would have but one system of practice," said the Ohio Commissioners, "we must have but one common set of rules in regard to parties." These statements appear to be slightly misleading, and need some explanation. The inference may be drawn from them that the Code has adopted chiefly those rules which prevailed in the equity system, making them applicable alike to both law and equity. But this is not entirely so. When the union or joinder of legal and equitable causes of action in the same action was authorized as it was by the Code, it was necessary to incorporate into the chapter on parties both those rules governing the law of parties and equitable and legal causes. But it does not follow that the rules relating to parties in equity can in fact be made applicable to legal actions. It is true that equitable rules were adopted, and on the face of these Code provisions they may read as if applicable to all actions. As the substantive distinction between rights and causes of action was not changed, it at once becomes apparent that being so, the law with reference to parties thereto is not changed without specific language to that effect. The Code has made the rule that the real party in interest may sue applicable alike to legal and equitable causes of action in so far as it may be. It will be remembered that at one time at common law a thing in action, not negotiable, could not be assigned, but that the assignee was permitted to sue in the name of the assigner. The assignment gave to the assignee all the rights except the remedial right to sue in his own name. The property derived from the assignment was equitable in its nature, rather than legal. Under the Code the right of the assignee is legal. The effect of the Code requiring that the real party in interest shall bring the action, is that where a thing is assignable and is assigned, the assignee must bring the action in his own name. This is imperative, so that where a thing is assigned absolutely to a third party, the assignee must sue on it in his own name, even though the contract of assignment provides that the assigners are to proceed to collect the monies due on the contract and pay the same over to the assignee. When a thing is absolutely assigned, the legal title is then vested in the assignee, who is the only proper party. The assigner is not a necessary party. This is the rule. 2. Where the assignment is not absolute, but is merely equitable, the equitable owner of a negotiable promissory note in his possession may maintain an action thereon in his own name. The equitable doctrine that the real party in interest must sue is thus carried so far as to enable one, who in equity is the real party, to maintain a cause of action which in its nature may be legal. For instance, under such a rule, a contract made between two parties for the benefit of a third, the latter though not actually named as a party and appearing as such may under this statutory rule sue at law upon the contract. The fact that the Code specially provided that anyone injured by reason of a breach of a bond may sue thereon, though the obligee be the state, rather indicates that the rule of the real party may not be extended to legal causes of action generally, and not much farther than may relate to equitable ownership. The provisions with reference to the wife and her right to sue, and to defend in her own right when husband and wife are sued together was passed to meet the advanced views as to the legal status of married women. The provisions of the Code enabling all persons having an interest in the subject of the action, and in obtaining the relief demanded may be joined as plaintiffs, perhaps has almost exclusive application to equitable causes. and from the very nature of things has a very limited application to legal causes, if any, so as to the provision providing that any person may be made a defendant who has or claims an interest in the controversy adverse to the plaintiff, or who is a necessary party to a complete determination of a question. It will be found to apply in general only to equitable causes. In some legal actions in which a corporation is a party, these sections might be so construed as to allow stockholders to intervene and take part in the litigation though the corporation be represented therein. So again the provision that when the question is one of a common or general interest of many persons, or when the parties are very numerous, and it is impracticable to bring them all before the court, one or more may sue or defend for the benefit of all, incorporates an equitable rule as to parties. The first part of the section perhaps applies exclusively to equitable causes, while the latter may apply to a limited class of legal actions. These general statements have been made to clear up an erroneous notion that the chapter in the Code on Parties contains chiefly the equitable rules of parties which are applicable indiscriminately to legal and equitable actions. The rules as to parties to actions are to be found chiefly in the substantive law, which remains the same because the Code did not change rights of parties nor the distinction between rights and causes of action. The right of counterclaim, set off, or defense were not impaired by the provision allowing the assignee or real party to maintain the action, which was made necessary because of the union of law and equity. The section which provides that any person may be made a defendant, who has or claims an interest in the controversy, adverse to the plaintiff, incorporates the equitable principle, and enables parties to settle all controversies in one suit, which formerly would have necessitated two. The Code Commissioners close their remarks upon the sections relating to parties as follows: we venture to express our belief that the foregoing rules on the subject of parties will remove many evils now existing, and will be found neither too stringent for suitors, nor too loose for the purposes of justice.